Today, we're going to talk about children's wishes and what if your child wants to live with you. And I have many people who come to me in my office and they say, hey, my son or my daughter is telling me that they want to live with me full time or they want to spend more time with me than they do with their mom or dad. So, that should be the end of the story, right? Because my kid wants to live with me. And I wish that the answer were that easy. It's not that easy. So if you think back to the best interest checklist, which is something that I'm always talking about, and you can get the best interest checklist at commandthecourtroom.com. And if you haven't gotten it, go there now and get it. Best interest checklist, commandthecourtroom.com. In that checklist, I list a whole bunch of factors that the court can consider, might consider, will consider in your case and make it a decision about custody and parenting time. And one of those factors is the wishes of the child or children. So a judge is going to consider the wishes of a child if that child is old enough to articulate his or her wishes. Now, what's the age at which point a judge is going to start considering the child's wishes? Well, it depends. Like everything in the law, it depends. It depends on the judge. It depends on your child. There are some children who are more mature at 8 years old than other 10 years old. So really, it depends on when your child can articulate his or her wishes. But I've come across many judges who say children, for example, under the age of 8 years old, they're not old enough to articulate their wishes or to reason. So I'm not going to consider it. I'm not going to have them interviewed. It's just too young. Yet I have had judges who've had children as young as 4 years old interviewed to determine what their wishes are. So I'm not aware of any place other than criminal court where a child has been allowed to be placed on the stand and asked in front of both parents what his or her wishes are. In my opinion, that's just unhealthy. It's toxic. It's bad for the child. It puts the child in the position of having to choose between parents, face both parents, and, really take a side against one or the other. So the way that determining a child's wishes is done where I am in Arizona is usually a court appoints a mental health professional to interview the child. And this mental health professional spends some time with the child, gets to know the child, tries to establish a rapport with the child, and tries to get at the subject that way. Now, the mental health professional doesn't just come right out and say, where do you want to live, with mom or dad? But they try to kind of get to the heart of it indirectly so the child doesn't feel pressured. But there are different ways that a child's wishes can come to be known. That's just one way, an interview with the minor child. And this interview can be done in the context of a custody evaluation, or sometimes in my cases, I just file a motion for interview of minor child. Sometimes in my cases, a court appoints what's called a court-appointed advisor to investigate certain aspects of the case. And that court-appointed advisor interviews the child as part of his duties and his or her roles. So there are different ways you can get that interview done. There are other counties where I am in Arizona where judges actually interview the children personally. And I know that in other states, this actually happens too. And, at least in front of the judges where I practice in Phoenix, Arizona, I don't know of any of them who interview the minor children, but there are judges out there who do it. And hopefully they've had some training on how to do this without making the children feel pressured, uncomfortable, stressed out, or tense. There are some situations where I've had children who have written letters directly to the judge. It's not my recommendation that a parent direct their child to write a letter to the judge. I had one client who did that one time. It wasn't by my advice, but she asked the child to write a letter. She insisted, that we submit it at court, and it infuriated the judge that parent would get the child involved in this way. That's a different situation, however, though, if, a child spontaneously writes something and you come across it and it indicates the child's wish to live with you. So, for example, in a case that I had several months ago, one of the children had made a Christmas list, and one of the wishes on that Christmas list was to go and live with daddy. And so, of course, that was an exhibit at trial, and it was our argument that was indicative of the child's wishes in this case. So one thing that you should know about child's wishes is that just because a child wants to live with you or the other parent doesn't mean that's what the court is going to do. So looping back to the best interest factors that I was talking about a few minutes ago, the court is going to look at all of the factors and making a decision about what's best for the kids. And I've mentioned this in past, but judges are very aware that as children start to get older, they get smart about what parent is the more lenient parent, what parent is going to give them more freedom. And maybe, that's the reason why the child or children might want to go and live with the parent. The judges understand that kids, although they're kids and we love them, sometimes they can be manipulative. They can play parents against each other. So just because a 16-year-old or a 15-year-old is saying, I want to live with mom, I want to live with dad, it doesn't mean that it's going to happen. A judge is really going to delve deeply into this, at least a good judge, and look at all the other factors to determine whether that child goes to live with one parent or the other. It's hard when you have a child who is older and that child is saying, I don't want to go with mom anymore, or I don't want to go with dad anymore. And I've had this come up several times also. Usually what I hear judges tell parents is that, just like you would tell a child, if the child was telling you, I don't want to go to school, you would tell your child, you have to go to school. Just like that, you have to tell the child, if there's a court order in place, you have to go see mom or you have to go see dad. It's a different story when you have a child who you have to force into a car or force into a plane. And I did have that situation once where the mother literally had to force the child to go see the parent physically. And we had to file. And with the judge, we had to file a lawsuit and tell the judge that, there are really strong feelings that this child has to the point that he has to be forced physically. And in the end, the judge ordered that child did not have to go see the parent. You have to remember, though, if you have a court order, you got to follow that order until the order is no longer the order. If you don't follow the order, there's a chance that you could be held in contempt, or the other side could petition the court to have you held in contempt. So the child's wishes are not the end-all be-all in these cases. One thing that's come up a lot for me too in my practice is I have a client who comes to me and says, my son or my daughter wants to come and spend time with me. They want to live with me more of the time. So we ask the court to do a child interview. Then we get the report back. And the report says exactly opposite of what my client thought it would. That's happened many, many times. And, so you have to be aware that's a potential outcome. You have to consider that maybe your child's telling you that they want to live with you more of the time because they think that's what you want to hear, because they want to please you. And they may be telling the other parent the same thing. It happens. When a child is in what they call a double bind, where they're like being pulled between the mother and the father. So be aware that your child may be telling you what you want to hear, or maybe not, but that's a potential outcome. So you